10 seconds, 5 seconds, start. The petitioner tenant has filed the present revision petition aggrieved by the impugned order of the additional rent controller dismissing the application of the petitioner for leave to defend the eviction petition filed in the proceedings of eviction initiated by the respondent landlord. The respondent filed an eviction petition under Section 14(1)(e) of the Delhi Rent Control Act 1958 against the petitioner. The respondent landlord claimed to have let out initially a portion of the first floor of the property, and in 1991 further portion was let out, but both the tenancies were consolidated in 1993. The premises was started to be let out for residential purposes, and the possession was sought on the basis that the premises were required bona fide by the respondent landlord and there was no other alternative suitable reasonable accommodation available to him. The first plea raised by learned counsel for the petitioner is that, in view of the averment in the affidavit in support of leave to defend application to the effect that the premises were let out for residential cum commercial purposes, the leave sought to disclose facts which, if proved, would disentitle the landlord from recovering the possession. But as per the ruling of the Supreme Court, the stage of deciding the leave to contest the application was a stage of judging the plausibility of defense, and the stage to prove was later. The plea of the petitioner has thus to be considered within the aforesaid parameters. There is no doubt that there is an averment in the application for leave to defend that the premises were being used for commercial activity, but admittedly rent receipts issued from 1993 onwards clearly specify the purpose of letting as residential. Before that, the purpose of letting was not at all mentioned. In fact, it is not disputed that the tenanted building is meant for residential purposes and has even been assessed to property tax as such. In view of all these facts, the additional rent controller found the purpose of letting to be residential. In my considered view, this finding of the additional rent controller does not require to be interfered with. No doubt, the stage for the test of substantial defense had not arisen, but there has to be at least a plausibility of defense. Otherwise, in every eviction petition, the mere averment that the premises were let out for residential cum commercial use would automatically give rise to an order for leave to contest the petition. This is not what is the law laid down by the Supreme Court. The title to the property has also been set out by the respondent, which is through a registered document. It is not for the petitioner to challenge the gift made in favor of the respondent, especially in view of the observations made in the case of Rameshwar Narayan versus Sarla Seren, wherein it was held that the word owner in section 14(1)(e) of the Act is not used in the sense of an absolute owner. It is only used in contradistinction with a landlord, as defined, who is not an owner but who holds the property for the benefit of another person.